current law in Texas for non-parent, or what we would call emotional parents.
Okay.
Sure.
And I have copies of my flow chart down here, if anything else. So, in the starting analysis of what happens when a gay or lesbian couple breaks up and one of them has a child. So the first point is you have to think about what is the legal definition of a parent. So are y'all in Justice Thomas's family law, or?
How many of you guys are in Justice Thomas class? How many of you are Professor Reader's class? Okay.
So have y'all studied what is the legal definition of a parent? No? All right, so the legal definition of a parent in the Family Code says that a parent is the mother, the biological mother, a man presumed to be the father, probably because of marriage, a man legally determined to be the father, a man who has acknowledged paternity, or an adoptive mother or father. Now, kind of going to David's area here, the definition of a parent might be a biological mother and an adoptive mother, right? So that's where some of us who do the adoptions kind of get to in doing same-sex adoptions and getting the legal authority, is that the definition of a parent includes adoptive parents. So if you have a person who thinks of themselves as a parent, who the child thinks of as a parent, but who does not meet that legal definition, that would be what in legal terms we would call a non-parent, or being respectful to that person, I call an emotional parent. So when you have an emotional parent who is seeking access to a child, you have a specific analysis that you have to do, and they're very difficult. So have y'all had CivPro, maybe? Do you know what standing is? Somebody know what standing is? Okay. So the first question, whenever I explain it to clients, I tell them the first question is who gets to enter the door of the courthouse? And then who gets to stay in the courthouse, right? So the first question is, how does a non-parent get standing to sue for access or rights to a child? And that comes from the Family Code standing sections, and generally the one we use is whether that parent has had actual care, control, and possession of the child for 6 months, ending not less than 90 days prior to filing suit. Now, there's a lot of legal wrangling that goes into that short little phrase. What does actual care mean? What does actual control mean? And what does actual possession mean? There's been a lot of cases litigating about what happens if the care, control, and possession occurs during the relationship. What happens if the relationship breaks up, but the two people continue to share custody, so to speak, not in a legal sense, but in a factual sense, share time with the child, kind of like a divorcing hetero couple might do? Does that rise to the level of actual possession, or does it have to be continuous? What does actual control mean? Does that mean that the non-parent has acted like a parent? Does that mean that it's happened without or with the consent of the biological parent? And if the biological parent is consenting to the non-parent acting like a parent, for example, taking the child to the doctor, then isn't the parent really controlling? How does a non-parent actually exercise control independent of a parent if the parent is the one consenting? Isn't that really the parent keeping control? And so then you have the timing requirements. So if you've got more than 90 days that expires between the last time the non-parent has seen the child, that person has a problem. And that kind of gets back to the question of if they break up and have kind of a split custody type arrangement, and 90 days goes by, is that sufficient under the statute for standing? Those are all questions that are being heavily litigated in Texas law right now. I had one of the cases on point, which is MKSV, and I think at one point in time, within a year of MKSB coming out, there were, I think, 9 or 10 cases pending in the courts of appeals across the state litigating these same issues. And I'm sure since I haven't kept count lately, there's been a whole lot more. Unfortunately, the Texas Supreme Court has not seen fit to take up these issues for us and give us some clarity.
And I wanted to, I've got one question on
Yep.
that. How, does the court have any discretion over that 90 days at all? Is it just,
No,
okay?
there is no discretion over the
parent,
timing.
anything?
There's discretion over the lawyer's ability to argue whatever your situation was might fall within the 90 days.
Okay.
For example, you know, an every other weekend type split of time with the child, whether that falls within possession within 90 days. But there is no discretion in the 90 days. So if you can prove that you have standing under this section of the Family Code, then you can keep going in your lawsuit. If you fail in proving standing, then you're kicked out the door of the courthouse and the courthouse doors are closed to you. So the next step in the question then becomes, if you have standing, what next? How many of you have studied the case of Troxel v. Granville? Nobody. Really? Have you ever heard of it? Well, Keith and I were discussing this before we started. A lot of people, when Troxel came out, believed Troxel to be a grandparent rights case. But in fact, it was a parents' rights case. So Troxel v. Granville came out of the U.S. Supreme Court. It was a case involving a grandparent whose child, the parent of the grandchild, had died. And the other parent of the child was denying the grandparent access. So the grandparent sued for access to the child. And leaving out a lot of the irrelevant parts of Troxel, what's relevant to this discussion is that Troxel very heavily upheld the constitutional right of a parent to parent their child. And so what the takeaway for this discussion is from Troxel is that a parent has a constitutional right. So we know that that's a right that's like way above just a regular right. I mean, this is like a huge, serious right that a parent has to parent a child without interference from the government. Government interference comes whenever, theoretically speaking, whenever a court orders a parent to do something that the parent does not think is in the child's best interest. Now, we obviously know that a court or a government can intervene in a parenting relationship if there's danger to the child, CPS type situation. But in a situation where the parent is basically a fit parent, doing a decent job, there's no child abuse going on, how does a government unit, a court, intervene in the parent relationship and say, Mr. Parent, Miss Parent, you must allow this grandparent access to your child on the first, third, or fifth weekends of the month, or whatever. So Troxel stands for that proposition that there has to be some proof that the parent is not a fit parent in order to intervene in that relationship. So for the non-parent, the next step in the analysis is proving that the parent is not a fit parent, which again is a very high hurdle. I mean, you would hope that all parents are being fit parents. Now, in that analysis, it's not good enough to prove that the child would suffer due to the lack of relationship with the non-parent. That's not enough. A lot of the grandparent cases out there that are kind of going through the same analysis say, you know, but I'm the grandparent and the child will suffer if she doesn't have a relationship with me. That's not enough. In Ray Scheller out of the Texas Supreme Court says that's not enough. You have to prove that there is some problem with the parenting of the biological parent. So if you rebut that presumption, and only if you rebut that presumption, does the non-parent then move to the question of, should there be conservatorship? Should there be access to the child for the non-parent? if you fail in proving or in overcoming the parental presumption, then you fail at obtaining custody. There was a case, if some of you are involved in the LGBT community in Dallas, there was a case of maybe a year ago, right around Christmas a year ago. Not one I was involved in, I hope you weren't, but very sad situation where a non-parent sued for access to a child when she and her partner broke up. She overcame the standing question. And unfortunately, the judge that was the judge of that court at the time disagreed with my analysis. My analysis is that it is a three-step process, kind of like proving up a common law marriage. It's a three-step process. You first have to prove standing. Then, in my opinion, there has to be a hearing to overcome the parental presumption. And then there has to be a separate hearing to overcome or to go through the best interest standard on whether there's conservatorship. That judge disagreed with my analysis. Not that I was involved in the case, but he and I had a specific discussion. And he felt that the parental presumption and the best interest question should be tried together. So he proceeded with a trial where the non-parent was forced to both overcome the parental presumption and show the best interest factors to obtain conservatorship. At the end, it was a jury trial, and at the end of the jury trial, she lost. And it was a very emotional loss for her. And unfortunately, a few days later, she committed suicide. And it was in the Dallas Voice pretty prominently. And no doubt, I mean, how horrible for her to have been awarded